Seems that we have everybody here. I'm going to ask for some help today. Is it pronounced Pezehan? Pezehan?
Oh, I'm sorry, Your Honor. Possession.
Possession? Could
Yes.
you do it for me again?
Possession.
Thank you.
Or as
I'm
it's
sure
referred to in the briefs, Fred.
We do find that a little easier because of the potential for misspelling, Your Honor. Yes.
Okay, we can do it that way too. I mean, I've been called Daryl before because of certain obvious reasons. I understand, counsel, you represent the appellant, is that right?
Yes, Your Honor, I do.
And that's not only because you have a great ability to pronounce, but also because you have skills in law, right?
Yes, sir.
Okay, how much time did you wish to reserve for rebuttal?
5 minutes, please.
I will try to give you, what is that used to be called in the military, your distant early warning, your due.
Thank you, Your Honor.
Thank you, counsel. Please proceed.
Your Honor, I am Deborah Corbishley. I have the honor of representing Mr. Fred Possession, together with my firm, Kenny Knockwalter. We are here today because the lower court imposed arbitration on Mr. Possession. As the court is aware, arbitration is in fact a favored child of the law, but it is not a remedy that can be imposed without an agreement. The court below imposed arbitration on Mr. Possession on statutory claims that do not arise from or relate to a contract, and it required him to arbitrate with parties who are not parties to the arbitration agreement that they invoke.
So we have some arbitration agreements that are contained within a purchase and sale agreement, which was back in 2008. Is that right?
That's correct, Your Honor.
And that is the alleged source of the authority to arbitrate, is those purchase and sale agreements that clearly do have arbitration provisions in them. So
Yes.
I think you're on the road to telling me what I want to know, which is why are the 2008 purchase and sale agreements containing the arbitration provisions, why are they not applicable to the case before us?
Your Honor, there are two independent reasons that the arbitration agreement in 2008 in the two contracts simply do not apply. One is that the parties seeking arbitration are not parties to those arbitration agreements for any reason whatsoever. And second, that there is no contractual nexus between the contract on which they hope to rely and the claims in this case.
So what we have is we clearly have a situation where the signatories under that 2008 agreement are different than those that are claiming to stand on the authority of that agreement before us, correct?
That is correct, Your Honor.
So there is no contractual right. Is there ever a circumstance where arbitration would be appropriate despite the fact that there is no signed agreement to arbitrate? Would that ever be appropriate? And
Yes,
if so, would that be appropriate in this case?
Your Honor, there are circumstances in which non-signatories do have the right to require arbitration. This is not one of those cases. The usual case is where there's a third-party beneficiary that seeks to invoke the arbitration clause, or where the signatory sues the non-signatory on the basis of the contract, and it is equitably unfair that the signatory can rely on the contract to impose a duty on a non-signatory and yet avoid arbitration. In this case, the first exception simply does not apply. There is, in fact, an explicit firewall in the two contracts. And in both contracts, it is section 10.3, and it says in both contracts, none of the parties hereto may assign any of its rights or obligations under this agreement to any other person without the prior written consent. There's an exception not applicable here in the Manhattan contract.
I think, as I recall, there was an affidavit filed by Mr. Possession saying, I didn't ever give my authority to extend the terms of this agreement.
That's correct, Your Honor. In addition, that section 10.3 goes further. Nothing in this agreement is intended to confer upon any party other than the parties hereto and their respective successors any rights, remedies, obligations, or liabilities. That's a firewall. There is absolutely no way under this contract that the two parties seeking arbitration can invoke any clause of the stock purchase agreements. If it's helpful, I can define the parties again. Parties to the two stock purchase agreements were Fred Pozeshkin in both contracts. In the contract involving Spectrum stock, Francis Rooney and Kevin Moore. And in the contract involving what was then Kraft Construction Company stock, the purchasing party was Manhattan Construction Group, Inc., an Oklahoma company. Not parties for any purpose, and yet the parties who sought to invoke arbitration were Manhattan Construction, Florida, Inc., which was formerly known as Kraft Construction, and Spectrum Contracting, Inc., both Florida corporations.
It's kind of hard to keep these players straight.
Yes.
I made several flow charts to try to make sure, but I think the bottom line is that the 2008 agreement, those that are seeking to enforce the terms of that agreement, which are referred to in the briefs as the Upper corporations, they simply are not signatories to that agreement. And under 10.3, that they're out of luck on that. That's your argument.
Yes, in fact, Your Honor, that is. In addition, assuming there are no more questions on the party issues, in addition, there is no nexus between this contract and the claims which the non-signatories seek to enforce. The party issue is a matter of fact that appears on the face of the documents. The nexus issue is a question of law. A contractual nexus exists if there's a significant relationship between the contract and the claims, and the parties have agreed to arbitrate it, which they haven't here. But a significant relationship does not arise simply because the dispute would not have arisen without the existence of the contract between the parties. Here, this dispute could have arisen in the absence of any stock purchase agreement. Mr. Pozeshkin was a shareholder before the stock purchase agreement was entered into.
To cut to the chase, are you simply saying that this appraisal process that Mr. Pozeshkin has initiated with his complaint is completely different from the purchase and sale that occurred back in 2008? One doesn't have anything to do with the other one, really.
That is correct, Your Honor. The statutory remedy is available to any shareholder in any of 10 circumstances which trigger a right under the statute that we have cited. Therefore,
well, in fact,
it is separate.
Mr. Pozeshkin was encouraged to bring a claim under that statute, as I recall.
Yes, sir. The corporations invoked the statute, used the corporate remedy, invoked the appraisal statute, and the appraisal statute could apply to any shareholder in any corporation that engages in any of, I think it's roughly 10 different kinds of transactions. It sets a specific way of measuring value, which is entirely different from the contract. And under the Verizon Wireless versus Bateman case, there is simply no nexus that would permit this statutory claim to be decided by arbitration.
Let me take the devil's advocate for a minute. I think under the purchase and sale agreement, there was a provision where the remainder of the shares that were held by Mr. Pozeshkin were to be purchased by the party 5 years after that purchase and sale agreement was executed. The remaining shares were to be sold to a specific entity. Does that help the other side at all?
I don't believe it does, Your Honor. In fact, that repurchase requirement, for reasons which don't appear in the record, never happened. And it applied in 2013. As you know, statute of limitations for breach of a written contract is 5 years. A specific performance claim has a statute of limitations of 1 year. And the statute invoked here sets a specific process for determining fair value. And the language of the statute is the current and customary techniques for valuing stock in a similar transaction. So the agreement was to purchase it at a set formula in 2013 by specific parties. For whatever reason, they didn't do it. For whatever reason, no one sued to compel anyone to do it. It simply went by the wayside. The time to enforce it has expired. And those parties are not the parties who have a right to who are seeking the repurchase. They're simply saying, let the companies buy the stock back, but let them get the same terms of the deal from 2008 that were supposed to apply in 2013. That doesn't help them. This invocation was many years later, after the statutes of limitations had run to enforce that provision of the contract. This was a no later than kind of contract. It wasn't a anytime after kind of contract. And here
Counsel,
again,
I would like to ask you one question as we deal with the arbitration clause. The term appraisal is one that's subject of definition. It's a determination of what constitutes the correct or value for purchase or for valuation purposes. It's a valuation. An appraisal equals a valuation.
yes, sir.
As I look at the 10.5 section in the stock purchase agreement, there seems to be three matters that require, that determine who has to go to arbitration. The first one is parties.
Yes,
The second is a dispute arising out of or related to the stock purchase agreement. Then they use the word and, which normally means in addition to the former, the latter requirement is also met. And it has to be involving a claim for money damages. I don't know, and I wonder if you agree or disagree, how is an appraisal an action for damages? It's not a breach of contract. It's not a tort. It's a mechanism or a process to arrive at a valuation.
Your
So
Honor,
if that's what it is, does that equal a damage?
we do not believe so, Your Honor. Appellees have argued that in fact it is. I think in that instance, the word is damages that matters. This is not damages from a breach of a duty, whether it's contractual or tort. This is a statutory remedy for a forced out shareholder.
This is a statute. We have all talked about the origin of our rights, whether in the Declaration of Independence is from our Creator. This one comes clearly from the legislature. The
Yes.
legislature has said, you have a right to an appraisal. You have a right to a valuation. It's not saying that there's a contract or a tort. So I'm looking forward to how the appellee is going to say this equals damages. I'm not sure how that gets there.
We don't believe it does, Your Honor. And in fact, we didn't find cases that specifically address that issue. I do know that appellees relied upon Black's Law Dictionary for what money damages are. What the appellees did not emphasize was the word damages.
Well, what precipitated this is the shareholder meeting to facilitate a reverse stock split, which had the effect of reducing Mr. Possession's shares down to fractions, which allowed the corporation to acquire his shares and remove him as a shareholder, correct?
That is, Your Honor. And in fact, he's not damaged. He simply
So the
doesn't.
statute says if you're going to remove a shareholder from his shares, you got to pay him.
That's right. It didn't reduce the value of
the
it.
way you determine how to pay them is they have a statutory right to have their shares appraised.
That's correct, Your Honor.
Dovetailing off Judge Casanueva, that seems to be a little different animal than a damages claim, but we'll hear from your opposing counsel on that, I'm sure.
Yes. Your Honor, I think we have adequately covered the points. If there are no further questions, I'll simply reserve the rest of my time.
Okay.
I can reserve your 5 minutes for you.
Thank you, Your Honor.
Thank you, counsel.
Good morning, Your Honors. Matt DeVise on behalf of the appellees, Manhattan Construction, Florida, and Spectrum Contracting. May it please the court.
Please proceed, counsel.
Thank you. And Your Honors, I'd like to begin the argument and address the court's questions in turn. First, with respect to whether the parties or the signatories to the stock purchase agreements are the parties that are seeking to compel arbitration. Before I get there, just a brief factual background, because the appellant's version of the case is very limited, both in the briefing and during today's oral argument. So I just want to provide the court with a brief background as to where the parties were and how they got there. So two separate stock purchase agreements. Very quickly, the first, the parties are Manhattan Construction Group, Fred Possession, and an unrelated entity, Craft Enterprises. And I'll refer to that as the MCG stock purchase agreement. The second stock purchase agreement, the parties are Mr. Possession, Kevin Moore, Francis Rooney, and again, the unrelated Craft Enterprises entity. And I'll refer to that as the Spectrum Stock Purchase Agreement. Directly relevant to both of those stock purchase agreements, in the MCG Stock Purchase Agreement, section 6.12, which is found at page 66 of the record. With respect to the Spectrum Stock Purchase Agreement, it's section 2.3, found at pages 93 and 94 of the record. Both of those provisions say that Mr. Possession is going to retain a minor ownership in the two appellee corporations, and after 5 years, he has an obligation to sell his minority ownership stake in those two corporations. Mrs. Corbishley said there's no evidence in the record or reflection as to why that never occurred, and that is not correct. What happened in 2013, the purchase and sale did not occur. There was an agreement between the parties that Mr. Possession would remain as an employee of the two corporations. And if you look at the stock purchase agreements closely, attached as Exhibit B to both stock purchase.
Counsel, your clients are not signatories to the 2008 purchase and sale agreement, correct?
So the appellee corporations are not. Manhattan Construction Group and
Appellee corporations are not. So I'm puzzled as to how the appellee corporations can claim a right to compel arbitration when they are not parties to the agreement that has the arbitration provision in it.
So I would point the court to record pages 254 to 263, which is the amended arbitration petition that was filed by Manhattan Construction Group and Francis Rooney, which are the signatories to the stock purchase agreements. And just quickly back to the factual background, I was setting the stage for the court in addressing that signatory argument. But what happened essentially is Mr. Possession stayed on as an employee. He ran up an approximate $300,000 receivable. There was an agreement between Mr. Possession, Manhattan Construction Group, the signatory, and Francis Rooney that they would waive that $300,000 or forgive that $300,000 receivable in exchange for Mr. Possession's relinquishment of his minority ownership in the two appellee corporations. Mr. Possession breached that agreement by filing the petition and seeking evaluation, seeking money damages for what he contends he owns the minority ownership stake in the two appellee corporations. Mr. Possession also breached section 6.12 of the first stock purchase agreement and section 2.3 of the other stock purchase agreement, which both say he will sell his ownership stake in the two appellee corporations by 2013. So if the court goes to the record, pages 254 to 263, the court will see an amended arbitration petition filed on behalf of Manhattan Construction Group and Francis Rooney, which both of those, or the entity and Mr. Rooney individually, are parties to the two stock purchase agreements. If the court goes to the record at 270 to 274, the court will see a second amended arbitration petition. Again, Manhattan Construction Group, a signatory, Francis Rooney, a signatory, filing an arbitration petition against Fred Possession, the other signatory. I would also point the court to record pages 306 to 312, which is a motion to intervene in the trial court case related to the motion to compel arbitration. The motion to intervene was filed by Manhattan Construction Group and Francis Rooney. Those are the two, again, signatories. There was a joinder attached to the motion to intervene. The court granted the motion to intervene. All three of those documents are found at 306 to 312. So it's very, very clear that there is a dispute between the parties. It may not be clear if the court only looks at the presentation of the case as to how the appellant has presented it. But there is undisputed record evidence in this record to establish that there is a dispute between the parties. I would further point out that—
Counsel, before you leave that point, let me ask you a question that relates to the point you're making. Let's assume there's disputes between the parties and who's entitled to enforce the contract. My concern is this: the legislature of the state of Florida has enacted a statute 607.132 et sec that says you have an entitlement to an appraisal. It seems to be it's a separate freestanding entitlement. We could use the synonym right. If I look at the contracts, I don't see any waiver of that statutory right. So if it's freestanding and there's no waiver or mention of that right in the contract, how can you compel them to arbitrate this action? I'm not concerned about the rest, but this statutory right, this action to enforce it, the plenary language in the statute, how does it go to arbitration when it seems the legislature said you have a right and the circuit court has jurisdiction?
So to address the plenary and exclusive jurisdiction argument,
Thank you.
Yes, I would point the court to the Preston versus Foray Supreme Court, United States Supreme Court case issued in 2008. And in that case, there was a dispute between an entertainment attorney and an artist over fees. Like the state of California had a statute that said the California Labor Commissioner has exclusive and plenary jurisdiction over that type of dispute. There was a written agreement to arbitrate between the parties, and the Supreme Court's holding is when parties agree to arbitrate questions arising under a contract, the Federal Arbitration Act supersedes state laws lodging primary jurisdiction in another forum, whether judicial or administrative. So the court should look to the United States Supreme Court's analysis and holding in that case. It's directly on point. There's a prior United States Supreme Court that also stands for the same proposition.
Does that case rely on the supremacy clause, preemption doctrine? Which one does it rely on in order to supersede the state? And if that is the case, how does that impact here? We're doing arbitration based on a written contract to be governed by Florida law, right?
The United States Supreme Court there was interpreting the Federal Arbitration Act, and Section 10.5 of the stock purchase agreements in this case specifically state that the Federal Arbitration Act applies. Further, a signatory, Manhattan Construction Group, to the first stock purchase agreement is an Oklahoma corporation, which would affect.
I'm fine. You've given me the link I needed, the 10.5. I appreciate that.
Well, before we leave that, how do you explain the October 7, 2019 letters to the shareholders telling the shareholders that what they need to do is assert their appraisal rights under Section 607-1301 to 607-1333? Says nothing about arbitration.
Yes, Your Honor, I explained that.
You're basically directing Mr. Pozeschkin to do exactly what he did, which is file a claim for his appraisal rights under 607. It was the whole notion of utilizing 607 was actually initiated by the appellee corporations.
Yes, Your Honor, I would address that by pointing.
Why isn't that a waiver?
Yes, Your Honor, I would address that by pointing the court, excuse me, to pages 352 and 353 of the record, which is an excerpt from the hearing transcript on the motion to compel arbitration, where appellee's counsel explained that the appraisal notices were sent in the alternative. And when I say in the alternative, I mean that at that time, Mr. Pozeschkin was in breach of the obligation to sell his shares, Section 6.12 and 2.3 of the different stock purchase agreements. He was in breach of the agreement that the parties came to, that the approximate $300,000 receivable would be waived or forgiven in exchange for his relinquishment of the shares. So at that point, it was done in the alternative.
I'm not familiar with that doctrine. How do you do something in the alternative? You either exercise your right to arbitrate or you don't. If you don't and you encourage a different right, even if it's inconsistent with arbitration, that's like saying you get your cake and eat it too.
I mean, these notices don't say anything about an alternative. They say, look, we're going to have this meeting. We're going to change. We're going to facilitate this reverse stock split. You've got rights here. You've got an appraisal right. Here's the statute you use. Go for it. Doesn't say anything about appraisal. Doesn't say anything about alternatives. It says, here's what we intend to do. Here's what you need to do, period.
So to address the third ciphered element and whether the appellees waived their right or acted inconsistently with the right to arbitrate, I would point out that they filed a motion to compel arbitration in the trial court. They filed two separate arbitration petitions with the American Arbitration Association, one with respect to the $300,000 receivable and then another with respect to the separate breach of the stock purchase agreement. They filed a motion to stay discovery. They objected to discovery. So if you look at the case law related to whether the right to arbitrate has been waived, the cases essentially say, has the party acted inconsistently with that right? And clearly here, there has been no unequivocal action to waive arbitration or actions that are inconsistent with arbitration. Again, all of the actions that I just mentioned are directly consistent with the right to arbitrate. With respect to the other questioning that was raised by the court and whether this—
Are we about to leave 10.5 and the federal stuff? Before we go, I went back and looked at that section. And here's what I'm hoping you will help me out with. The first sentence says, and involving a claim for money damages shall be resolved pursuant to the commercial arbitration rules of the American Arbitration Association. Suggestively, that's the rules that govern. The second sentence, all arbitration shall be final and binding and shall be governed by the Federal Arbitration Act. Does that mean the act comes in upon finality? What does the first sentence pursuant to mean and then governed by in this context? Or is the language there created some sort of ambiguity?
No ambiguity at all.
I've not worked with this before. That's why I'm asking you.
No ambiguity at all. The language is very clear. It says it's governed by the FAA. And even if the court were to find that language ambiguous, you would still have interstate commerce being affected, which would still implicate the FFA. And
is the federal act governing it after the award? Because it says it's filed pursuant to the commercial arbitration rules of the American Arbitration Association. So that seems to suggest a procedure to get to verdict. And then there's a period. And it says all arbitration shall be final, conclusory, and binding, and shall be governed by the Federal Arbitration Act. So does the Federal Arbitration Act come in when we're dealing with finality?
no,
And only that? Or does it come in for pursuant to procedures? Or do they somehow interlock?
the Federal Arbitration Act comes in from the beginning, and the court would look to it, just like the Supreme Court did in the Preston versus Foray case, and determine under the FFA whether the court can enforce an arbitration provision in a written agreement between the parties. And that's exactly what the court should do here. The court should look to Preston versus Foray. The court should look to section 10.5 and say all of the elements are met, the trial court is correct, and the order should be affirmed. With respect to the last set of questioning in connection with whether this is a claim for money damages, again, the analysis ends when you look at the $300,000 receivable claim that is in the record at 270 to 274, 254 to 263. Clearly, that's a claim for money damages. The separate breach of the stock purchase agreement, clearly a claim for damages. Even if the court were just to look at the petition for fair value of the shares in a vacuum, which I submit the court should not do, if you look at the wherefore clause of their own petition, and this is at the record page 16, it says, Mr. Possession respectfully requests that this court enter a judgment in his favor, determining the amounts that respondents are obligated by the act to pay Possession for his shares, including interest. Now, if we go to the statute that the petition for fair value was brought under, section 607.1330, subsections 5 and subsection 6, those subsections specifically reference the entry of a judgment for money damages. There is no doubt at the end of the day, Mr. Possession is looking for a money judgment saying that the valuation of my shares total almost $2 million and you owe me $2 million for performing the work reverse stock splits. No question about that. We've also cited to the Black's Law dictionary definition of damages, clearly meets that definition. The only other argument I wanted to address was the significant relationship test, and that relates to the second separate element, whether an arbitrable issue exists. For that analysis, we look to the Florida Supreme Court's analysis in the Jackson versus Shakespeare Foundation case, 2013 Florida Supreme Court case. The court could also look at this court's analysis in Bateman that was issued in 2019. In those two cases, the courts essentially say significant relationship means contractual nexus. Contractual nexus means if in deciding the dispute, the court or the fact finder would either have to reference or perform a construction of the written agreement that contains the arbitration clause. Here, undisputed, the first thing the court would have to do is go to section 6.12 and 2.3, read those provisions, come to an understanding that Mr. Possession had an obligation to sell his shares, come to an understanding that he breached that obligation. Even if you look at their own petition for fair value at paragraph 8, 37, and 39, which is record pages 7, 12, and 13, they reference those specific provisions of the stock purchase agreements, section 6.12 and 2.3. And even if you look at the appraisal notices that the court was referencing earlier, those notices reference that those two sections, 6.12 and 2.3. 6.12 says the way we're going to come to the value of the shares is multiply the book value by 1.61. Section 2.3 of the Spectrum stock purchase agreement says same thing. The way we're going to do the book value or the value is the book value times 1.72. And that is how the signatories came up with the value of the two stocks owned by allegedly owned by Mr. Possession that were transmitted through the appraisal notices. So all of the separate elements are clearly met. There's a written agreement to arbitrate that governs. There's an arbitrable issue or many arbitrable issues, and arbitration or the right to arbitrate has not been waived. Just one other minor argument. If the court does not accept for any reason the argument that the signatories are actually compelling arbitration and were to ignore the arbitration petitions, the motion to intervene, the court can still find that this case should go to arbitration under the doctrine of equitable estoppel and agency, and that's the Altrecht case from the Florida 3rd District Court of Appeal 2014 and the Otto Beck sales case, first DCA 2018. So equitable estoppel would apply here. That's in the alternative because it's very clear there's a dispute between the parties here. With that, the appellees would request the court affirm the trial court's order compelling arbitration. Thank you.
Thank you, counsel.
Thank you.
Okay, let me clear. We are ready now, counsel, for rebuttal.
Thank you, Your Honor. I would begin with a review of Statute 607.130, subsection 5, which opposing counsel relied upon to say that this is a claim for money damages. He perhaps intended to paraphrase the statute when he said that it provides for a judgment for money damages. The specific language: each shareholder made a party to the proceeding is entitled to judgment for the amount of the fair value of such shareholder's shares, plus interest as found by the court. There is no reference whatsoever to damages or money damages in that statute. It is specifically a fair valuation. Turning to Preston versus Foray, we perhaps eluded a bit over the question of parties. And the federal court, just like the Florida courts, require that there be an agreement by the parties to arbitrate. This claim before the court is a claim for a statutory remedy against non-parties to the arbitration agreement. Why does it matter? Because there is a difference in how we determine the value. If, in fact, the interveners were bringing the claim in the first place, first of all, they're seeking the stock. They're not seeking money damages themselves. They want the stock. That's a claim for specific performance, and it doesn't fall within the terms of the arbitration clause. In addition, they're raising a separate contract for their rights. It is a contract which Mr. Possession disputes. There is no evidence in the record of any agreement whatsoever. They merely issued a payroll document without reference to stock. There are some tax issues there which are well beyond the scope of this argument. But what they're seeking to enforce is apparently a separate agreement entirely. And what they want really is specific performance. They want the stock. That's not arbitrable. Mr. Pozeschkin did not sue on the stock purchase agreement. The corporations, who are the non-signatories, did not seek to take his stock under the stock purchase agreement. They didn't have a right to do that. The dispute under the stock purchase agreement simply isn't what this arbitration motion was about. It is about whether the corporation has offered fair value under the statutes for the reverse stock split and the forced buyout. We're not here on whether Mr. Pozeschkin breached his obligation to sell to the signatories. We're here on whether the corporations, non-signatories, offered fair value. This is not a dispute among the parties. And I don't believe I have any other points other than to say that were the court to affirm the trial court, it would be an imposition of arbitration where there was no consent to arbitrate with these parties or this kind of a dispute with anyone. As a matter of contract law, Mr. Pozeschkin did not agree to arbitrate with the Manhattan Florida company or with Spectrum, the value of his stock. The court would have to rewrite the contract between Mr. Pozeschkin, another corporation, and two other men to give the two corporate appellees here the right to arbitrate. That is clearly forbidden under Florida law. The lower court erred, and we ask that you vacate the order compelling arbitration. If there are no further questions, I appreciate the attention and time. Thank you.
Thank you. Thank you both. Well presented.
Well
The
argued,
court
both.
very much appreciates it.
Thank you.
Interesting case.
Challenging as well. I think the pleasure of the panel is to take a break now. And I have 26 after, so 15 would be what, 41?
Sounds good.
We'll be in recess until 41 after. Thank you and safe, well, if you're local, safe travel.